This is Stephen Luskin. I'm the host of the Oregon Divorce School webinar. It is another Thursday night, and I'm glad you're able to join me. We have quite a few people online tonight. So tonight's topic is do-it-yourself divorce in Oregon. And I'm going to go through and talk about what makes a good, who should file a divorce themselves and who should not. I'll go through sources of information, where you can get information, find forms, and things like that. And we'll spend about an hour going through this topic. I do this every other week or so. The intent of these podcasts is to give people, or webinars, I should say, is to give people information that they can use. This is not self-promotion. If you're interested in my website, you're certainly welcome to visit it. But my general and sincere intent is to get information to the public. So with that, let's begin. So our agenda tonight is I will talk about myself, which I have gotten very good at. Then we'll get into the more serious stuff. We'll talk about finding resources to do a do-it-yourself divorce. We are going to spend some time talking about the risks of doing it oneself. And again, who should and who should not. We'll talk about finding the best forms, overview of the forms, and then the process. And that should wrap up the evening pretty well. My name is Stephen Luskin. I am a attorney, mediator, arbitrator. I've been in practice in Oregon since 1992. I've been doing divorce since about 2001. You can find my website, luskinlaw.com, online, and you can send me an email to Stephen Luskin at Luskin Law. I generally don't accept comments or questions during the webinar, but I'm happy to take the occasional question or phone call uh, to answer questions. And you're free to use my contact information for that. I may not give you, a deep analysis of your problem, but I'll certainly walk things through with you. Okay, so let's start off with resources and what's available out there. One of the best sources for do-it-yourself um, information for legal issues is NOLO Press. I've had plenty of contact with NOLO over the years. I've looked at their literature, and I like it and uh, recommend it, although it is not state specific. And Oregon law, like every jurisdiction, can be very specific and can have things that can trip somebody up easily that you wouldn't necessarily know. Uh, Divorce law does vary from state to state. Process, how a case gets through the courts, varies from state to state. No two states are identical. And so NOLO can give you a good overview, but it's not going to be the be all and end all for finding information about a do it yourself divorce. Another place to look is the Oregon State Bar. The bar has plenty of information on family law in it, and that can be considered authoritative. For do-it-yourself um, forms and information, local court websites almost always in Oregon have a family law department, and that department will have its own section on the website and will contain the forms that the court likes to use. Oh, okay. Another source of information that you can use that has plenty of good information is the Oregon Judicial Department website. I omitted it from this list, but it's also a very good source of information on family law. So you can just type into your web browser Oregon Judicial Department, and that will come up with good information. The Oregon Judicial Department is not the Department of Justice. The Oregon Judicial Department is the branch of the government that runs the courts. The Oregon Judicial Department, which will become important later, is the department that represents the state of Oregon in legal proceedings. So two very different entities, and they do very different things. Another source of information is the family law resource centers at courts. There's usually um, somebody who in an office who is on staff to help people fill out the forms. They will tell you repeatedly that they cannot give legal advice, but they can help you fill out the forms or pick out the forms. Um, there is also, and lastly, this comes under the heading of a warning, there's also a ton of information online about Oregon divorce, Oregon family law, and family law forms. My strong advice is be really careful what you're reading. I get people who call my office all the time saying, I read online, and I will quickly discover that what they were reading pertained to Washington, or in my view, was just not correct, or um, just was not a correct statement of the law. Somebody else may say that about my website. Somebody may say, well, you didn't get the law quite right. So I would urge you to be careful about what you're reading. Make sure that it's an authoritative site. Make sure that whoever you're reading has credentials in the area that they're practicing. Specifically in terms of online forms, if you type into your browser Oregon divorce forms, you'll get private companies that offer services, fill out the forms and they'll file it for you. I have no idea of the quality of those services. I suspect that you get what you pay for. So, um, some of them are just misleading on the face, $137 for divorce. Well, plus the $301 that you need to pay for the filing fee, right? So just check it out if you're so inclined, but do so with your eyes wide open. Let's talk about understanding the risk of doing a do-it-yourself divorce. So suppose you're an average couple and you've been married for 10 years or whatever, and you have kids and a house and retirement. Um, there's a lot of commingling that goes on, and there's a lot of you build a life together. The relationship itself is an entity, right? And that's what you're um, pulling apart when you divorce is that entity. And so there's going to be a lot of things that are easily to separate, like bank accounts, but there are going to be things that are not easy to separate, like a house with two names on the mortgage, or a pension or a retirement account. So the that entity, that relationship, um, when you pull that apart, there are risks that it's not done correctly, and so uh, those are the risks that I want to talk about now. So can every person do a do-it-yourself divorce? Yes, absolutely. But it's not recommended if, in my view, it's not recommended if there's a house, if there's kids, if there's complicated financial instruments, if there's retirement accounts that require um, federal law, somebody with knowledge of federal law to prepare the documentation necessary to make a transfer of assets. Sometimes people have complicated financial instruments or need complicated medical or financial planning in the divorce, particularly. And those are people who it's just going to be complicated to separate those things, and mistakes can be costly and sometimes irreversible, right? So you want to make sure that those are done right. And um, uh, I can't tell you that the cost of the attorney is going to be worthwhile, but my strong recommendation is always going to be to spend the money just to get it done right for the peace of mind, to make sure that it's done in accordance with law and is done with an eye towards anticipating future conflict. So uh, again, my view is that people who just need divorce, right? Maybe they have some assets, maybe they have some liability, and that's easy enough for them to split up. Fine, you can do a do-it-yourself divorce. You can download the forms that we're going to talk about and file those with the court yourself. Um, but if there's any complications in the relationship, in the a house that's duly owned, a retirement accounts that are complicated, financial instruments, or kids. My strong view is that even if you're able to agree on most things, that you should have some professional help doing the papers and the court documents to bring the divorce about. Um, how difficult is it to do? So the state of Oregon puts out divorce forms, and there are 7 forms that need to be filed for every divorce. And a lot of the information that the state requires is simply objective biographical information: date of birth, social security number, driver's license, where you were born, your names, that type of biographical information, and that's easy enough to do. The um, complicated document is always going to be the judgment of dissolution, and that's where choices have to be made. And if you use the form, your choices, if you use the state's forms, your choices are necessarily going to be limited to the options that the state gives you, right? So um, uh, those forms are written and drafted for um, the most general audience, and um, uh, they don't particularly go into anomaly situations, or they don't, not particularly. They don't go into anomaly situations or unique situations. They're written for the widest possible audience. So um, it's not that hard to do the divorce. But for example, if you have children, you have to do a child support calculation, and I will tell you where that is in a little bit. You also have to do a parenting plan. I will tell you where to find a parenting plan in just a moment. But if you haven't been through this before, you don't know where those things are. And the instructions uh, that come with the forms, they're okay. I've read them plenty of times. They're okay, but it's still, first time out. It's important to get it right. And it's like, it can be as daunting as like, putting together an IKEA cabinet. Um, what happens if you're doing the divorce yourself and there's a screw up? For example, supposing there's real estate. So these examples come from people who I represented years ago. In my law practice, probably when my rates were lower, I used to have a lot of people call me up and like, we did it ourselves, we screwed up. What do we do now? You couldn't spend the money on an attorney now. You could have avoided it by hiring an attorney, but people come in and say like, how do we resolve this? So I had a case years ago where a couple had done divorce themselves. There was property, and they did not provide for what would happen with the equity in the house when they sold the house. That was completely an open question. So under Oregon law, you cannot modify a property dispute, a property division, right? So you can appeal it, but once your name is on the paper or once the judge's name is on the paper, it can't be modified. So however the judgment is written pertaining to the property, that cannot later be modified. You can modify a judgment for spouse support. You can modify a judgment for custody, parenting time, and child support, uh, but you can't modify a judgment that pertains to property, right? So real property or um, personal property cannot be modified. So a couple comes in and they say, we have uh, a judgment and it says that the house is going to be sold, but it doesn't say who's going to get how much of the equity. And as I recall, one of the spouses put in money in the down payment and they wanted that back, but that was also not in the judgment. So the rule is you can't modify the judgment. The court um, doesn't necessarily have jurisdiction over um, the judgment anymore. So correcting that mistake was expensive and time consuming, and ultimately they had to come up with an informal agreement to uh, um, divide up the property and then put that in the form of a supplemental judgment. Um, but it was still not a it was still something that easily would have been avoided had they had some professional help overlooking what they had done. Uh, retirement accounts. Retirement accounts can be complicated, right? If like you're going to make a transfer, supposing there's $100,000 in a retirement account that was all in marriage and still on marriage, and the spouse will say, "Well, we divide everything equally in those circumstances, so $50,000 is going to go to the husband, its wife's account." So If it's an IRA, it's reasonably simple, but if it's in a 401k or other pension, it gets very complicated. The other thing about retirement account is that the transfer has to be made within a certain amount of time, and that time can either be 10 or 20 years. If it's done, if it's done after 20 years, I misspoke. If it's not done within 20 years, the judgment falls away. The judgment expires, and you can't go back and now say, well, I want what's in the retirement account. Well, I want what was owed to me on the retirement account. You can't do that because there's no more judgment. So there are just things like that that um, make it complicated, and something that an attorney would tell you is that you need to make this transfer within, now. The third thing is, supposing one of the spouses, you finish the judgment, you file it with the court, judge signs it, and then comes back and says, "Oh, I forgot, I want spousal support." Can you get spousal support later? And the answer to that is no. Once the judgment is signed, you can't add something into it that was overlooked. Uh, um, so, um, can't a competent attorney would say, well, that would be one of the questions. Do you think you're entitled to spousal support? And if so, then we put it in the judgment. So, um, there are risks to not having some professional help putting together a divorce. Okay, so let's get into finding the forms. There's two general sources of information for divorce forms. Like I said at the outset, if you um, go and type into your Google browser Oregon divorce forms, you'll see a number of private companies that offer uh, services to put together a divorce. I'm not familiar with those, and so I don't have anything to say about those. But the two sources that you want to look at are the Oregon Judicial Department and your local courthouse. The Oregon Judicial Department offers multiple different form packages, whether you're the petitioner or you're the respondent, whether you have kids or you don't have kids. You pick the right um, um, package, the package that's appropriate to you, and you download a fillable PDF, and then you file it with the court. Uh, and those packages come with instructions. I sat on the committee that developed not those particular forms, but that sat on many, that developed many of the forms. And when I look at the forms, I look at them and say, ugh, these look amateurish. They're not great forms. The information is generally good. It's generally kind of okay presented, but the forms themselves, you will do the trick of getting you divorced, right? So go to Oregon, type in your browser, Oregon Judicial Department, divorce forms, and that will get you to the right place in that website, the Oregon Judicial Department website. And so you are going to pick out the right forms that's appropriate. There's also an iForm option where you can do it online and it will kick back PDFs to you, and that's available also. There is not an iForm option through the local courthouses. So if you are in Coos Bay, for example, you can go to the Coos County Courthouse or the Wasco County Courthouse, and most of the state courthouses in Oregon have a section called Family Law, and they'll have their own forms. You can use those. Those are probably preferable because the local judges will know what's in the forms, and you can fill those out, download them, fill them out, and then bring them into the court. So those are also available. So the two official places where I'm recommending you get divorce forms are the Oregon Judicial Department and your local courthouses. So I'm not going to go through and do a demonstration on how to fill out the forms. You can bring the forms into the local court, the local family law resource centers at the court to do that. But I do want to give you an overview of what's in the forms and what forms there are. So every packet will contain these forms or something called a response, right? So these are the forms for the petitioner, for the person who's filing divorce, uh, and they will contain, if there's no marriage and there's kids, then it's a petition for custody. So a petition for dissolution, a petition for custody, you have to fill out a form called a confidential information form, and that tells the world that you have filed something called a confidential information form, and there's two of those, one for the husband and one for the wife. Those forms ask for current names, former names, address, current address, uh, driver's license, social security, and birthday, and then employment information. And so that information is required for both the husband and wife, and also for kids. The next document will be a declaration. A declaration is a sworn statement given under oath, right? And um, the sworn declaration uh, makes out the prima facie case for the judgment, right? So that's saying that we have these assets, we have this debt, this is the accurate biographical information. The judgment is not sworn. So the declaration is what gives the court or another party uh, security that the information is the judgment and the judgment is accurate, because there are penalties for filing a false statement or a statement given under oath that's false. And so that's what the declaration does. It gives security that the information in the judgment is accurate and sworn and has penalties if it's not. And so not not accurate, meaning deceptively, not intentionally deceptively, not accurate, not a simple mistake of fact. Like I tell my clients and people who I do uncontested divorces for, the only document that has any importance in all of this is the judgment. You can put anything in the petition, uh, but what has to be in the judgment, what's in the judgment, is what actually controls um, your post-marital relationships with your spouse, right? And so that document has to be accurate and complete and contain the entire agreement between the spouses. So the judgment is what both parties sign and submit to the court. It's what the court will ultimately sign. And once the court signs, that's what ultimately divorces a couple. So the divorce is the judgment is the most important document in in the in the divorce process. Um, I wrote vital statistics fee. That's not correct. It should say vital statistics form. You're also required to submit a record of dissolution form um, with the when you file your divorce documents, and then you can get that at any courthouse. It's just a straightforward form to fill out. There's a $301 filing presently. At the time this is recorded in June 2026, there is a $301 filing fee throughout the state to file a petition. It's also $301 to file a response. So far, we've been talking about petitions where there's a petitioner and a respondent. It's also possible to file as co-petitioners. I generally don't do that. I've been doing it more and more, but generally I file petitioner respondent just because it's a little cleaner than co-petitioners. But there are divorce packages out there that allow for um, co-petitioners as opposed to a petitioner and a respondent. So some specific things to keep in mind. For children, as we mentioned, it's not enough just to fill out the judgment. You also have to complete a parenting plan. You can find parenting plans on the Oregon Judicial Department website. The parenting plan form on the Oregon Judicial website happens to be very good. It's one of the few forms that I think is really, really well done. There's a reason for that. It doesn't matter here. But of all the forms that you may fill out, that one is the most comprehensive. It's the easiest to use. It's the most detailed. Gives most and also gives most flexibility. And You will fill that out with your spouse. You'll both sign it and then attach that to the judgment. The other thing that you need to fill out for children is the child support calculation. Both parties are required. Uh, let me say it another way. Um, the child support calculation is mandatory. It has to be in the judgment. Uh, and you cannot not have child support unless there's like extraordinary uh, reasons not to pay child support. Both parties, the child support payor, the person in the house, is required to pay child support. It's not optional unless there's very specific circumstances. So the child support calculation must be attached to the final judgment. So you go to the Oregon Department of Justice website, you will see the child support section, and then you'll see a tab that says child support calculator. You put in your income numbers, you put in your spouse's income numbers, you put in information about paying and receiving spouse support, medical expenses, health insurance, whether or not anybody's receiving Social Security disability or veterans benefits, or are a union member, and what the child child care costs are. All that information goes into a spreadsheet, and then the state tabulates it and gives back a number, and that number is child support. It's not a negotiated amount, right? So that, and then when you're done with that, it will give you back a PDF, and that PDF gets attached to the judgment. And all of the numbers that were input to come up with the child support calculation need to be in the appropriate place in the judgment, and that appropriate place is under the findings of facts at the very beginning of the judgment. Some other specific things is real estate. If you have a house worth, $500,000, $400,000, and there's going to be some equity in that. Maybe the equity is, $250,000. You've been in the house for a while, and there's equity. Why you would not spend a couple of grand to have an attorney do the divorce is beyond me. Mistakes connected to real estate can be fatal, right? You cannot modify the judgment, right? So you want to make sure that it's done correctly. And there is just a lot to know about transferring real property in a divorce, how it's done. There's only really a couple of permutations about what will happen. One spouse keeps it and buys the other out. One spouse keeps it outright. The house is going to be sold now or in the future, and the proceeds divided. Or lastly, somebody's going to remain in the house and buy the other's equity out. Like those are the only options. But each of those has certain things that have to happen to bring that about. Even if it's just the spouse is going to continue living in the house, that still has to be done in a very particular way, because anything pertaining to real estate is always public, right? It's always recorded, right? Anytime you put a lien on a house, the lien becomes a public document and is recorded for the whole world to see. And it's the same in the divorce. Anything pertaining to real estate is public. And so you got to make sure that everything is done correctly, and so that you're not coming up with something that you didn't foresee during the divorce process. Finally, another kind of warning, retirement accounts. Retirement accounts can be very complicated. Financial instruments can also be complicated. And retirement accounts can involve federal law. All of divorce is state law. Everything we've been talking about so far is state law. Retirement accounts can get into purviews of federal law and can be very complicated. When I have retirement accounts that are going to be transferred, I hire somebody else to do that work for me. I don't do it myself. And so let's get to some wrap up here. So in conclusion, I'm here to tell you, you can do a divorce yourself. The forms are available, and there's plenty of resources and information. Something that I didn't talk about, but I will mention it now, is that there are attorneys who will look over, you pay them, they'll spend some time looking over your paperwork. They're out there. I don't offer that as a service, but there are plenty of other opportunities, other attorneys who will. The reason I don't do it is because um, I need to understand a couple's um, situation, and I need to verify, in my mind, I need to verify what people are telling me. And if somebody's just coming in and says, "Can you read this over?" I don't have that option. I'm not making any independent decision. So really, like, what's the point of me reading over the documents? There are other attorneys who are not um, who don't believe that. They think, well, we can still get it done correctly, and they still may be able to make some suggestions. That's just not my the way I operate. But there are attorneys who will pay the money and they will go over your judgment to make sure that it's right, or as right as they can make it in these limited situations. The best candidates for do-it-yourself divorce are people or where couples they may have property, like personal property that they can transfer bank accounts or debts that they can divide up themselves, but they just need the divorce. They just need to get on with their lives, and that's perfectly appropriate setting for do-it-yourself divorce. As we talked about quite a bit, the forms are available online, and they are most suitable for a general audience, and very well may not be appropriate for your particular situation. All of the online forms that we discussed come with instructions, and my recommendation is, read the instructions. If you're having trouble with the instructions, hire an attorney. Local courthouses may have a family law resource department, and they may review your forms for you, but they will tell you your divorce forms, but they will tell you that they don't give legal advice, and so they're what they can help you with may be pretty circumscribed. And then lastly, like I just mentioned just a minute ago because I forgot it was number 5, is that some attorneys will review forms for you to charge a couple $100, and that you may find that helpful and give you some security when you're filing a divorce. I guess I didn't put a section here, but I want to go through. This is an oversight from on my part. I want to go through the process of filing forms. So after, suppose you and your spouse have filled out all the 7 documents together, and you're ready to file the form. You can bring the forms to your local courthouse and give the court, and just do it all at once, right? So you've done the petition, you've done the declaration, you've done the confidential information forms, you've done the judgment and the vital statistics forms. Just bring all of that to the courthouse at once, along with the $301 filing fee. If there's kids, the court will need proof that you've been to the child education class, um, and so you can bring that with you as well. So you bring everything just at once. A lot of times attorneys will say, we'll just file a petition and they get the judgment filed later. I think the better practice is just to bring everything to the court once you're done with it and you have everything filled out and signed. The court will then review it and make sure that there's not mistakes. If there's mistakes, they will kick back the documents to you for correction, and then you'll have to fill them out again and refile them. Once the court has accepted the documents as being free from error, it will go before a judge, and the judge will sign the judgment, and then the court will let you know that you're divorced. Well, to let you know that the judgment is signed, and then at that point you are divorced. In Multnomah County, it will take easy 3 to 5 weeks to get the judgment signed. In Clackamas, it can happen overnight. I just did a divorce in Deschutes County, and it was 2 days. So Multnomah County is the outlier in how long it will take. But I've also found that they are the most picky in terms of getting the documents right, and that's a good thing to my mind. That's always a good thing. So Multnomah County could take you longer, but it'll be the same process. You bring your forms to the courthouse, pay the filing fee, and then once the court reviews, make sure it's correct, and the judge signs it. At that point, you're divorced, and the divorce is done. So that's an overview of doing it yourself divorce. Thank you for attending. We had quite a few people tonight. Again, I'm happy to take phone calls or emails to answer questions that you may have had during the presentation tonight. So thank you for joining me, and we'll look forward to seeing you next week. Thanks.